So the Basic Education Department says it will abide by the court's ruling after Afriforum filed an urgent application to oppose the department's decision not to publish the 2021 Matric results on public platforms this week. Now, this is in compliance with the Protection of Personal Information Act, which came into effect last year. Now, the Information Regulator has also weighed in, saying that the department has a duty to ensure all pupils receive their results in a manner, that does not violate their right to privacy. Information Regulator Member Alison Tilley joins us now via our video link to explain at least the circumstances under which the results can be shown publicly. Alison, it's great to see you. Thanks very much indeed for making time. Let me begin by asking this. Are you at all surprised that the Basic Education Department won't be opposing this court action, given the provisions of the POPIA?
Well, we've had a number of discussions with the Department of Basic Education, and they are obviously the experts in how they release these records. So we've really valued, their explaining it to the regulator. I think what you have to do is come back to one of the key sections in POPI, which excludes the processing of personal information that has been de-identified. So that's the language the Act uses. So it says if information has been de-identified, then it's no longer considered, it's exempted. There's an exclusion in the Act which excludes it, but it is also then no longer defined as personal information, because personal information must be information that is connected to an identifiable person. And so I think whenever you see, and you'll see this a lot with research in particular, where you're dealing with particularly with sensitive health records, that you will create a number or a sequence of numbers and letters that you will then relate to a particular individual. You'll only use that sequence of numbers and letters, and then only one or two or three people who are in charge of the research hold the key to which name fits to which unique identifiers. So I think that that is really the rule around which this whole discussion has turned at the end of the day.
So apologies for coming in there. So the sense I'm getting from you is part of the argument that's likely to be made in court is that using a matriculan's student number, for argument's sake, is de-identified data, and on that basis wouldn't be in breach of the POPIA.
Well, that's certainly one of the provisions of the Act that will come into play. I may be interested in the journalistic exclusion when information is then in the hands of the media. The Act doesn't apply for the processing of personal information solely for the purpose of journalistic expression. So there is another exemption which is at play here, but I doubt that will be the issue around which the decision will turn.
Right. Very quickly, if the court decides that in fact the results can be published, and the Information Regulator, for instance, later discovers that this was in breach of the Act, what kind of recourse would they be? I imagine just a fine to the department, if of course they accept that they've been in breach of the law.
Well, the regulator has powers to do an investigation, make a finding. We have an enforcement committee, which is headed by a judge, and that committee is able to hand down fines and sanctions. So there are remedies, and particularly if there are pupils who, for any reason, discover that their personal information has been made available and that the system of unique identifiers hasn't worked, they're obviously, would have every right to lay a complaint with the regulator.
All right, Alison Tilley, thanks very much indeed for letting us in on what you know. Alison is a member of the Information Regulator. Once again, I do appreciate your time.